United States Bankruptcy Court Northern District of Florida Gainesville Division www.flnb.uscourts.gov. In re. Lynette Michelle Lacey Alexis Preston, aka Lynette Michelle Lacey Alexis Corrados, aka Lynette Michelle Lacey Alexis Cook, SSN ITIN, XXXXX2618. Case Note 2510173 KKS Chapter 7. Debtor. Debtor's reply to creditor Jeremy Hales. Response in opposition to debtor's emergency motion to enforce the automatic stay and for damages pursuant to 11 U.S.C. Section 362 K. Comes now the debtor, Lynette Michelle Lacey Alexis Preston, by and through undersigned counsel, and hereby files this reply to creditor Jeremy Hales. Response in opposition to debtor's emergency motion to enforce the automatic stay and for damages pursuant to 11 U.S.C. Section 362 K. Introduction. The creditor's response fundamentally mischaracterizes both the nature of the automatic stay and the limits of state court jurisdiction in bankruptcy matters. Hales argues that the automatic stay does not apply to sanctions proceedings because the debtor was the plaintiff in the underlying state court action. This argument conflates two distinct legal principles: the rule that a debtor may continue to prosecute her own claims, and the fundamental protection afforded by the automatic stay against actions seeking to impose monetary liability on the debtor. The motion for sanctions under Florida Stat. Section 57.105 is not a continuation of the debtor's lawsuit, it is a separate and distinct claim against the debtor seeking to create new monetary liability. Moreover, while state courts have limited concurrent jurisdiction to determine whether their pending proceedings are subject to the automatic stay, the state court here exceeded the bounds of that limited authority. The Second District Court of Appeals decision in Christopher v. Bank of America, N.A., 323-3D838, Florida, 2D-DCA 2021, makes clear that a state court's concurrent jurisdiction extends only to determining whether a proceeding is subject to the stay, not to determining whether a particular debtor is entitled to the stay's protection. By proceeding to adjudicate entitlement to sanctions while acknowledging the existence of the automatic stay, the state court exceeded its limited jurisdiction, and its order is void ab initio. Argument I. The automatic stay applies to the sanctions proceedings regardless of the debtor's status as plaintiff in the underlying litigation. Hales' primary argument rests on the proposition that the automatic stay does not apply because the debtor initiated the underlying state court action as plaintiff. The cases cited by Hales, including Home Am. Inc. vs. T&J Paving, Inc., 544 So 2D 1076 Florida, 2D DCA 1989 Calway vs. Calway, 352 So 3D1 Florida, 4th DCA 2022 and P&S and Company. LLC v. S.J. Mock, LLC, 254 So 3D 535 Florida, 3D DCA 2018, stand for the proposition that the automatic stay does not prevent a debtor from prosecuting her own claims. None of these cases holds that a debtor who files a lawsuit forfeits all protection from the automatic stay with respect to claims asserted against her in that litigation. Homem involved a debtor plaintiff whose case was dismissed for lack of prosecution while a bankruptcy petition was pending. 544 So 2D at 1076-77. The court held that the automatic stay did not prevent dismissal because the automatic stay provisions of Section 362 of the Bankruptcy Code, 11 U.S.C. Section 362a, apply only to actions brought against a debtor in bankruptcy. ID at 1077. The court did not address whether a creditor could pursue affirmative monetary relief against the debtor within that same litigation. Calway involved sanctions imposed against a vexatious litigant who had filed a bankruptcy petition after entry of an amended order barring her from filing further submissions. (352 So 3D at 1-2). The 4th District Court of Appeal affirmed, concluding that the final order on appeal did not involve an action against appellant as a debtor or against appellant's bankruptcy estate. ID at 2. The sanctions at issue in Calway barred future filings rather than imposing monetary liability. P&S and Company involved post-judgment supplementary proceedings against non-debtor third parties after a judgment debtor entity filed bankruptcy. (254 So 3D at 537-38). The court held that the automatic stay did not preclude impleading non-debtor third parties because those proceedings did not seek relief against the debtor. ID at 538-39. The court confirmed that the clear language of Section 362a stays actions only against a debtor. ID at 538. The plain language of 11 U.S.C. Section 362a(1) stays the commencement or continuation, including the issuance or employment of process, of a judicial, administrative, or other action or proceeding against the debtor that was or could have been commenced before the commencement of the case under this title, or to recover a claim against the debtor that arose before the commencement of the case under this title. The motion for sanctions seeks to recover a claim against the debtor within the meaning of the statute. The Florida 3rd District Court of Appeals en banc decision in Nattel Med. Imaging, LLC v. Leon Finn, serves. 349 So 3D 895 Florida. 3DDCA 2021 is instructive. In that case, the court receded from Shop in the Grove, Limited vs. Union Federal Savings and Loan Asset of Miami, 425 So. (2D 1138 Florida. 3DDCA 1982, and held that the automatic stay applies based on the plain text of the Bankruptcy Code. The court stated, the Act's text is clear and unambiguous. The debtor's filing of a bankruptcy petition stays any action or proceeding against the debtor, including the continuation of an action or proceeding against the debtor. ID at 896. The court further stated, We leave bankruptcy policy to the United States Congress, and will, henceforth, follow the clear congressional mandate manifested in the text of the automatic stay provision. ID at 897. Hales argues that state courts have concurrent jurisdiction with bankruptcy courts to determine whether proceedings before them are subject to the automatic stay. The Second District Court of Appeal in Christopher v. Bank of America, N.A., 323 So 3D 838, Florida, 2DDCA 2021 explained the precise scope of this limited jurisdiction. Christopher involved a foreclosure sale that occurred while the debtor's fifth bankruptcy petition was pending. 323 So 3D at 839-40. The Circuit Court declined to vacate the sale, finding that the debtor was ineligible to be a debtor under 11 U.S.C. Section 109 G1. ID at 840. The Second District reversed, holding that the Circuit Court possessed limited jurisdiction to answer a discrete inquiry, whether its pending proceeding was subject to the automatic stay. Its limited focus is upon the pending proceeding and not upon whether the debtor, as here, is legally entitled to the benefit of the automatic stay. ID at 841. The court further held that the Circuit Court exceeded its limited power afforded by concurrent jurisdiction by determining that Mr. Christopher was not entitled to the protection of the automatic stay. Its reach was only to determine whether the proceeding was subject to the reach of the automatic stay. ID at 841-42. The Christopher Court quoted in Ray Glass, 240 BR. 782, Banker, M.D., Florida, 1999, for the proposition that the court in which the litigation claimed to be stayed as pending has jurisdiction to determine not only its own jurisdiction but also the more precise question whether the proceeding pending before it is subject to the automatic stay. Christopher, 323 So 3D at 841. Quoting in Ray Glass, 240 BR at 787. The Christopher Court also cited 11 U.S.C. Section 362d and noted that, in those instances where the automatic stay does apply to a given action, only the bankruptcy court may grant relief from its terms. ID at 842, quoting in Ray Glass, 240 BR at 787 N.5. The state court in the present case acknowledged the existence of the automatic stay but proceeded to adjudicate entitlement to sanctions. The question of whether the sanctions proceeding is subject to the stay is distinct from the question of whether the debtor is entitled to its protection. Under Christopher, a state court's jurisdiction is limited to determining whether its pending proceeding is subject to the automatic stay. By proceeding to adjudicate the merits of the sanctions motion and entering an order determining entitlement to sanctions, the state court made a determination regarding whether the debtor was entitled to the stay's protection. Such a determination exceeds the bounds of the state court's limited concurrent jurisdiction. 3. The state court's order is void. Actions taken in violation of the automatic stay are void and without effect. In Ray Striblin, 349 BR. 301, 303 Banker, M.D., Florida. 2006 Quoting Borg Warner Acceptance Corp. Versus Hull, 685 F2D 1306, 1308 11th CIR. 1982. The Christopher Court recognized this principle, citing in re Striblin for the proposition that an action taken in violation of the automatic stay has been determined to be void and without effect. Christopher, 323 So. .3D at 842, quoting in re Striblin, 349 BR at 303. Echo River Sanctuary, LLC version 21st Morgue, Corp. 348 So 3D 1191 Florida. 1st DCA 2022 further confirms that filing a bankruptcy petition triggers an automatic stay of all proceedings against a debtor effective the date the petition is filed and actions taken in violation of the stay are void even if there is no actual notice of the stay. ID. At 1196-97, quoting Personalized Air Conditioning, Inc. vs. C. M. S. Wise, of Pinellas County, Inc., 522 So 2D 465, 466 Florida, 4th DCA 1988. Hales may argue, relying on in re Glass, that state court decisions interpreting the scope of the automatic stay are not void ab initio. In re Glass stated, the court rejects debtor's implicit argument that a state court decision interpreting the scope of the automatic stay is void ab initio. 240 BR at 787. This statement must be understood in context. In re Glass involved a state court determination that a contempt proceeding for failure to pay child support was accepted from the automatic stay under 11 U.S.C. Section 362, B2A(e). ID at 783-84, 787. The bankruptcy court applied the Rooker-Feldman doctrine and declined to disturb the state court's determination that the proceeding fell within a statutory exception. ID at 787-88. The present case differs. The state court did not find that the sanctions proceeding fell within a statutory exception to the automatic stay. The state court instead proceeded on the theory that the automatic stay does not apply to proceedings against a debtor who initiated the underlying litigation as plaintiff. This determination ventures beyond the question of whether the proceeding is subject to the stay and into whether the debtor is entitled to its protection. Christopher held that such determinations exceed the bounds of state court concurrent jurisdiction. 323 So 3D at 841-42. The Christopher Court's holding that the Circuit Court exceeded its limited power afforded by concurrent jurisdiction, and its recognition that stay violations render actions void and without effect, provide the applicable framework. ID at 841-42. Hales may also contend that the bankruptcy court has authority to retroactively annul the automatic stay under 11 U.S.C. Section 362d in re bar, 318 BR. 592 Banker, M.D., Florida. 2004 recognized that Section 362d permits bankruptcy courts, in appropriately limited circumstances, to Grant retroactive relief from the automatic stay. ID at 598. Factors relevant to such a determination include whether the creditor had actual or constructive knowledge of the bankruptcy filing, whether the debtor acted in bad faith, and whether grounds would have existed for modification of the stay if a motion had been filed before the violation. ID at 598 to 99. The court should consider these factors in determining whether retroactive annulment is appropriate. Hales had actual knowledge of the bankruptcy filing, as demonstrated by the memorandum of law filed in the state court on December 8, 2025 that expressly acknowledged the existence of the automatic stay. IV. The debtor is entitled to damages for willful violation of the automatic stay. Section 362(k)(1) of the Bankruptcy Code provides that an individual injured by any willful violation of a stay provided by this section shall recover actual damages, including costs and attorneys' fees, and, in appropriate circumstances, may recover punitive damages. The 11th Circuit in Re Jovengig, Inc. vs. IRS, 92F3D 1539, 11th CIR 1996, adopted the test used by other circuits for determining whether a stay violation is willful. The court stated that IRS's conduct was in contempt because IRS 1 knew the automatic stay was invoked and 2 intended the actions which violated the stay. ID at 1555-56. The court explained that other circuits find automatic stay violations willful if the violator 1 knew of the automatic stay and 2 intentionally committed the violative act, regardless whether the violator specifically intended to violate the stay. ID at 1555, citing Price vs. United States, 42F3D 1068, 1071, 7th CIR. 1994, Citizens Bank vs. Strumpf, 37F3D 155, 159, 4th CIR. 1994, in Ray Goodman, 991F2D 613, 618, 9th CIR. 1993. Counsel for creditor Jeremy Hales filed a memorandum of law in the state court on December 8, 2025 that expressly acknowledged the existence of the automatic stay and argued that it should not apply to the sanctions proceedings. The state court's order likewise acknowledges the automatic stay. Hales and his counsel knew of the automatic stay. Despite this knowledge, Hales and his counsel continued to prosecute the motion for sanctions and obtained a post-petition order adjudicating entitlement to sanctions against the debtor. These actions were intentional. The debtor has been injured by this violation of the automatic stay. The debtor has been forced to retain counsel to file this emergency motion and to seek enforcement of the automatic stay in this court. Pursuant to 11 U.S.C. Section 362(k)(1), the debtor is entitled to recover her reasonable attorneys' fees and costs incurred as a result of the violation. The Hales, sword and shield, argument is an apposite. Hales argues that the debtor cannot use the automatic stay as both a sword and a shield. This policy-based argument originated in Shop in the Grove, Limited. The Union Federal Savings and Loan Asset of Miami, 425 So 2D 1138 Florida. 3D DCA 1982, where the 3rd District Court of Appeal held that the automatic stay did not apply when a debtor-defendant appealed an adverse judgment. The Shop in the Grove Court reasoned that the purpose of the automatic stays, shield, is actually thwarted when the debtor uses the stay as a sword to indefinitely suspend the debtor's own efforts to be relieved of an adverse judgment. Shop in the Grove, Limited. 425 So 2D at 1139. The 3rd District Court of Appeal receded from Shop in the Grove in Natal Med. Imaging, LLC v. Leon Finn, serves. $349 So 3D 895 Florida. 3D DCA 2021. The court in Natal Med. Imaging addressed whether the automatic stay applied to appellate proceedings where the debtor was the defendant in the underlying litigation. The court held that, while Shop in the Grove stated policy rationale may seem reasonable, we find the opinion's conclusion to be without support in the clear and unambiguous text of the Act's automatic stay provision. We leave. Bankruptcy policy to the United States Congress, and will, henceforth, follow the clear congressional mandate manifested in the text of the automatic stay provision. ID at 898. The debtor acknowledges that she was the plaintiff in the underlying state court action, and that Natal Med. Imaging involved a debtor who was the defendant in the original proceedings. The dispositive question is not who initiated the underlying lawsuit, but whether the sanctions motion itself constitutes an action or proceeding against the debtor, or an action to recover a claim against the debtor, within the meaning of 11 U.S.C. Section 362(8)(1). The plain language of Section 362(8)(1) operates as a stay of the commencement or continuation, including the issuance or employment of process, of a judicial, administrative, or other action or proceeding against the debtor that was or could have been commenced before the commencement of the case under this title, or to recover a claim against the debtor that arose before the commencement of the case under this title. A motion for sanctions under Florida Stat. Section 57.105 seeks an independent award of attorneys' fees against the party found to have engaged in frivolous litigation conduct. The sanctions motion is not a defense to the debtor's claims, it is an affirmative request for monetary relief payable by the debtor. When Hales sought and obtained an order adjudicating entitlement to sanctions against the debtor, he was prosecuting an action to recover a claim against the debtor. The state court's order creates a monetary obligation against the debtor that, once reduced to a sum certain, could be collected against the bankruptcy estate. This is precisely the type of post-petition proceeding seeking to establish monetary liability against a debtor that the automatic stay was designed to prevent. The principle articulated in Natal Med. Imaging compels courts to follow the clear text of Section 362(8)(1) rather than policy-based exceptions. Regardless of who initiated the underlying lawsuit, the motion for sanctions is a discrete proceeding seeking monetary recovery against the debtor. The statutory text controls, and Section 362(a)(1) stays actions against the debtor, and actions to recover a claim against the debtor, without exception for claims arising from litigation the debtor initiated. Conclusion. For the foregoing reasons, the debtor respectfully requests that this court grant the emergency motion to enforce the automatic stay and for damages pursuant to 11 U.S.C. Section 362(k), declare the state court's order granting defendant's motion for sanctions void ab initio pursuant to the rule that a. Sanctions taken in violation of the automatic stay are void and without effect. In Re Striblin, 349 BR 301, 303, Banker. M.D. Florida. 2006, citing Borg Warner Acceptance Corp. versus Hull. 685 F2D 1306, 1308 11th CIR 1982, enjoin Hales from taking any further action to prosecute the sanctions motion in state court, and award the debtor her reasonable attorneys, fees and costs incurred as a result of the willful violation of the automatic stay.